Yes, certain people. Once. Yes, certain people. Once.
She said, Chanda के विषय तो बेचारी की डेथ हो गई
Yes, please. On the first question about this insurance, I have some observations to make on the paragraph 205. I have some reference to para 133 of the judgment. They'll come back on the question as to whether there was. And then, in view of the fact there were two things which happened, please turn to 205 at page 159. Two things which happened. Please turn to 205. Volume 1 of the responsive compilation.
Yes.
Then comes the question, which we post at the end of paragraph 135. Then comes the question. This concern.
Just 1 second.
I'm sorry.
Sorry. Page.
This respondent number 1 compilation, the review judge.
Okay. Sorry. Page.
I may as well go back to page 132 at the bottom of para 135, which is what's referred to in para 205. 132 bottom, just below placitum tail. What about those who are presently only asymptomatic and have no material to support a present claim? Who will provide the medical surveillance costs, and if someday in the future they develop any other dreaded symptom, who will provide them with compensation? Even if the award is and once and down for determination, these aspects must be taken into account. Then 205 at page 159. Then comes the question which we pose at the end of para 135. This concerns the exposed members of the population of Bhopal who are at put to risk and who, though presently asymptomatic and filed no claim for compensation, might become symptomatic in future. How should case of yet unborn children of mothers exposed to MIC toxicity, but the children are found to have or developed congenital defects be taken care of? So kindly turn over to the directions part of it.
Yes.
And which is at page 164.
Yes.
The para D. In respect of the population of the affected wards, excluding those who have filed claims, Government of India shall take out an appropriate medical group insurance, so on, etc., for compensation to those who are presently asymptomatic and filed no claims for compensation might become symptomatic in future, and to those later born children who might manifest congenital or prenatal MI affliction, that no upper individual monetary limit for the insurance, the period of insurance so and so number is 1 lakh. Therefore, I'm told that in view of two developments, one that about several hospitals that have been set up, including the Bhopal hospital, to take care of the medical needs of persons who might not have filed claims at all, and which seem to be still keep coming. So the medical facilities and free insurance, free medical facilities there seem to be taken care of this aspect of the matter. But I'll come back on the question as to whether government actually applied its mind on this and how they took a decision. I need a little more time. I would like, because that's not very clear today, but what I am told is that in view of this, the medical part of it being taken care of, whether the compensation will also be input. That I don't want to make any statement which will not be accurate.
You are saying medical needs are taken care of by free treatment in hospital, so we don't need to take out insurance.
No, I'm not. I don't. That's information given to me. I would like to verify this. Please.
But that
I won't be in a position to make.
Yes, Bhopal Medical Hospital has now been closed. It has been given to somebody else.
No, there are 6 other
That's fine.
hospitals which are where medical assistance is being.
For this purpose, when the hospital was started,
The Bhopal
that is now
Memorial
been-
Hospital.
Memorial Hospital, that now been closed.
But the other medical centers where people go for a medical treatment, they are still functioning.
So we're covering the added cases.
I'll come. Filed claims and were already covered under various categories of disability, ailments, etc. So these are that's why excluding.
There appears 5 to 6 categories of that as per the scheme. And out of that, those persons who fall within that category, they are being provided. the
There could be
medical
other categories also. But that's how, for instance, cancer. There are other 2 categories for those 2 categories. But the excretia payment were made in 2010 and keep making payment up to 2022. The government has continues to make payments for those people. The applications are not closed as far as those are concerned. I put it so in my note.
Yes.
Therefore, that's an entirely different set of people, other than those who filed claims, 1 lakh earlier, which then now has become 5.74 lakhs. And so that perhaps should not be reckoned for the purpose of considering D, paragraph D. So, but I'll come back on the question whether there was conscious decision taken or not as far as the insurance. So, what government of India did on that, I'll come back on that question. I need a little time. But I want to make this preliminary explanation saying this. What was intended was only to cover those who are not part of the present claimants set of group. And if there are others who may deserve an assistance of compensation, how do we take care of it? That's how the court probably looked at it. But if we come back to the only the trust of this or the hospitals, the 6 hospitals I'm told are functional and they're taking treatment from those hospitals. So that's how the research by ICMR, it continues to happen. Post 2016, studies keep happening and placed on record how the categories of other ailments come to the notice of the ICMR, research process. So in 2012, this court said you must continue to have these medical facilities, have a research facility, and ICMR will do that. All that is a detailed set of instructions are being followed. I was drawing the Lordship's attention to the National Commission for Women's Judgment, which which is in volume 1 of the compilation of judgment. What I would like to probably say is that there is one instance where the strict requirement of the party filing a review petition or parties to the proceedings and then successful in the review, thereafter file the curative petition. There is one case where your lordships, by reason of the importance of the case involved, permitted the National Commission for Women, were not a party to the earlier proceedings, and they were permitted to file a curative petition. The curative petition was granted. So there could be any number of instances where, in grounds of public interest, public importance, public good, where
They were not party to the original proceeding. No?
NCW was not a party.
Therefore, they turned to
Was never a party. And here, of course, in the review judgment, lots of notice the paragraph where the Supreme Court says that we supported the review, even though we did not.
para 51. That is why it says of Hurra's case that entitled to access to justice is that a violation of principles of natural justice. In that, he was not a party to the rest, but the judgment adversely affected interests, possibly coming under this first category, not being a party to the rest.
That's right. No. NCW interests were not affected, except as a public body,
Not to,
who has an interest.
not to represent the interest of the, he was not party, but to represent the interest of a category of people.
Correct. Therefore, Union of India stands on the same footing.
You are party.
I was a party, but I have a larger interest than NCW. I have a greater interest.
You are party to the proceeding.
That's true. But what I'm
That's
trying to
it.
point out
You are
is
party to the proceeding, party to the settlement, party to everything.
no, that he was not a party to the Lisbon judgment adversely affected the interest. Therefore, your lordships put it on a wider footing. It is not at a personal interest. It's an interest of an institution.
That's why
It can be the
in any
interest.
case you had stepped into their shoes today.
Correct. The
There was
interest
no
of
doubt
the
about that.
institution.
Yes.
So if the interest of an institution is paramount, and certainly your lordship permitted to do so.
Yes.
So the strict requirements of only parties to a list, and in the absence of filing a review petition, you will be precluded from proceeding with a curative. I think that
All I'm putting to you is that was a party, not party to the list, sought to represent the interests of a group of people. And in that position, the curative was entertained. That's what I'm saying.
let me read that husband. But
What will that do? Does it say discuss all this?
the context is that an institution which tries to represent a certain interpretation of provisions of the Indian Penal Code. So the question is not who comes, but the question is what is the public importance? And there is an interpretation question which affects a large number of people. So the question is therefore if there could be any number of such circumstances where public good or a public interest or a constitutional interpretation or an error of judgment which leads to miscarriage of justice. So all those will fall in the category of permitting.
Your deep research also you have found out this order is the only order.
I'm only looking at para 51 to say that the very strict reading of 51 will not come in the way of Union of India not having filed a review petition can still maintain a curative petition. It is one example, which is a recent example. Examples could be multiplied, perhaps.
Different facts, how it is done, why under 142 it is exercised. Issue was raised about locus standi. You turn to para 10.
Locus standi in the sense of participation, the presence of.
They have entertained firstly, it's an order. There's no judgment of this issue. You should have overlooked. But it will entertain to that extent, you are right. But it said so in view of these facts.
That's true, but the facts are. The view that so far as the objection relating to the local standard concerns the same is not tenable. And according to the fact that we are not dealing in this matter with a statutory right, but a constitutional provision, the Article 142 of the Constitution. And in fact, and Article so and so pass orders to justice between the parties. The issue involved is not one against Monica alone, but the interpretation or the expression cruelty within 498A. And in paragraph 1, and in paragraph 214 of the review judgment, paragraph 214 at page 162 of the review judgment, disposing of those 162 bottom and 162 top. Let me read it. We might now sum up the conclusions reached, finding the recurrent directions divided contention. 1. The contention that the apex court had no jurisdiction to withdraw to itself the original suit pending in the district court at Bhopal and dispose of the same in terms of the settlement. And the further contention that similarly the court had no jurisdiction to withdraw the criminal proceeding that rejected. What's the reason? The reason is given at page 163. It is held that under Article 142 of the Constitution, the court had the necessary jurisdiction and power to do so. The suit was virtually withdrawn. And having said on 42, paragraph 11, the court says National Commission is enjoined to certain statutory duties, and therefore the court considers it in the fitness of things to permit NCW to file a curative petition. I would probably urge, there's the instances can be multiplied in future now. How it happens, one does not have to speculate now. But in the facts and circumstances case of this very hugely adjudicated issues, and with two important judgments as milestones to throw some light to this matter. If the curative petition proceeds to present a very highly arguable question of an error vitiating the settlement for a good number of reasons. I say with great respect, the curative petition has been rightly presented in the larger interest of justice to the Bhopal.
In this
That's
National
victims.
Commission's case, we will kindly say, in this was a case filed by the Curative Petition of the National Commission for Women in Review Petition number 12 and Criminal Appeal number 12. Disposed of at the court of search. You know, they have filed the petition, then they are upon the curative.
Under the Gas Leak Act, both under Section 3 and 4, Section 3 government took over the right and acted exclusively as in a parent's patriot capacity. So having kept aside the victims from being party to the proceedings, and which also received its affirmance in the two judgments. Now, Section 3, which is available at the same volume 1 at page 176 of respondent compilation. Because if throughout these proceedings, Union of India alone was permitted to represent the interests of the victims, it shall continue to do so as long as Union of India is able to present an arguable case that the settlement needs a reconsideration. And that flows from the provisions of Section 3, exclusive right to represent, and then Section 4 at page 177. Notwithstanding anything contained in section 3 in representing and acting in place of any person in relation to any claim, the central government shall have due regard to any matter which such person may refer to the urge with respect to his claim. So this, the central government, I say with respect, can do suo motu because it has taken over the entire responsibility of supervising and ensuring extension of all assistance, including the payment of compensation. So it can do suo motu and can also receive any information or representation which can persuade the Union of India to act in terms of Section 4. Therefore, Section 3 and 4 jointly authorize the central government, and that's why I said that is a power coupled with a duty. These are two provisions which must be construed as powers coupled with duties. And that's where I draw a parallel with the NCW judgment. Yes. In our, there are 3 volumes of judgments compilation which have placed before the court. I'll just indicate, and they also set out the subject matter of the judgment. Volume 1, to know about curative and review powers. There are about 7, 8, 9 judgments there. This in the index, it's the citations and the paragraph numbers. Volume 1, you will also see that. The second volume is on reopening of settlements, very 3, 4 judgments. And the third, in the same volume, I have placed on the third the principle of continuing wrongs and liability for continuing wrongs. And also some judgments on tracing and restitution, etc. In the third volume, we have this duty to do complete justice, ubi justice, ubi remedium, which the Bandhu Mukti Mocha case has dealt with. And we also placed and record a judgment in 2016 on the power coupled with the duty, where the court looks at a series of cases from 1952 SCR, Commissioner of Police versus Godandas Banjit, 135, which looked at another old English case, Julius versus Bishop of Oxford, power coupled with duty. I'll place some of the judgments. No.
Yes, what do you want to say?
There are submissions. One with Martha prepared on some aspect. I have another set of submissions with actual submissions by the Attorney General. So let me read some parts of the learned ASC's note,
Yeah.
and then switch on to my note. So we have this at page 1. It says, false Wiley.
Yes.
Within the parameters of curative petition laid on by so and so, judgment provides for broad parameters, exercise inherent power to reconsider judgment. We give it?
So non-inadequacy of
Yeah.
sensation,
So we are happy.
reparation and the intent.
So which note you are reading out of the two?
No, yeah, maintainability.
Reading the maintainability one first.
But my note deals with certain other aspects as well. So para 1, it says the judgment provides broad parameters and the Honorable Supreme Court makes the inherent power to reconsider judgment. Relates to the rarest of the rare cases where reconsideration of a final judgment is required to set right in miscarriage of justice, prevent abuse of process, obligatory both legally and morally to rectify the error, duty to do justice prevails over the policy of certainty of judgment, declining to reconsider would be oppressive to judicial conscience and cause perpetration of irremediable justice, neither advisable nor possible to enumerate all grounds on which a petition may be entertained. That's very important. And ex officio justicia, he establishes violations of the principles of natural lordship of that paragraph. And next, paragraph 4, where it talks about the most devastating human tragedy caused by an environmental disaster. That's why it's the rarest of rare cases. And keeping in mind, I'm trying to, again, thinking aloud, why do we say it's one of the rarest of rare cases, which and the Hura judgment, for all its deepest bestowal of consideration to situations which may confront the court in doing complete justice in a given cause or a matter. Cause or a matter, what Article 142 talks about. So the court has bestowed the attention and said, these are very obvious reasons why, after a review, there could still be a lingering reason which may persuade the court to continue to do justice. In the very nature of things, I suppose the Hura judgment was advisably said that these are not exhaustive of the possibility of any other very appealing reason which may persuade the court to add on to the list of categories.
So now you are saying by this note that Hura, which itself was an exception, should be expanded.
Time, while certainly expressing the need for having a settlement as the only good solace beyond that. As for the finality was never drawn.
We've repeated ad nauseum. How can they finality when there was no trial? You chose not to have a trial. In your wisdom, and rightly so, you
That's
chose
why
not to have a trial. Now you want to say, well, a trial, we didn't go for a trial because it would have been a very prolonged affair.
That's
We
why
took a conscious decision. Now you're going on the premise that trial would have been held.
I'm not inventing any new propositions. The para 214 which I read out, court said I'm rejecting the contention that the withdrawal of the cases from a suit or Supreme Court is illegal. The court rejects that contention. And why are we doing that? We are doing it in Article 140. Therefore, the suit no longer survives. All those proceedings which went
We
on.
want the suit to continue. You were the
I know.
instigator of the suit.
Therefore,
You
it's one of those
instigated
rarest of the rare cases where Lord may
the
find
suit.
value in that statement or not. The rarest of the rare cases where, without being relegated to those proceedings, since the proceedings of before this court continue to be before this court. So, what this court can do, treating it the rarest of the rare cases, falling within the Hurrah domain, and so by
What is the rarest of
stating
the
a few additional
you yourself rightly said, in class action suits, a lot of them get settled. Many of them get settled. We've not had, tort law has not been one of the areas where law has been greatly invoked in India. This was one of the few cases where it got invoked. Class action suit was filed. It was settled in the manner where the US courts, which have possibly the maximum amount of such claims, get settled. Most of them get settled through a negotiated settlement, which is what was done here.
how do you lost it?
Paragraph 188 says in review that there is no judicial determination on the question whether the company was liable. Now, assuming that we accept your all arguments, first thing we'll have to undertake exercise in this curative petition is to decide whether they were liable. Liable to pay compensation, because that's the observation at paragraph 188. So there is no adjudication on that question. So can that be done in a curative petition to go into the question of
We are no longer, that question of liability is no longer a matter at large.
Why?
In a sense, because that's right. It's no longer a matter at large. They bought peace by getting us entering into a settlement.
This is a self-defeating
And
argument, attorney. You say we filed the suit.
the
they
question
bought
of
peace.
liability.
Supreme Court says, well, without going into this issue, it is being
Nee.
determined. Now you say there's a quietus to this issue because liability is presumed. Now-
Liability is not really presumed because
Yes.
it has been a concluded state of things, namely that you went to the US courts and said you will not
Where
adjudicate
is
the
there,
proceedings.
after the observations in the review petition, where is there a conclusion post any adjudication of evidence that they are liable? Please tell us. Let's not act on presumptions.
No, not on a presumption. The whole issue of jurisdiction has been canvassed.
issue of jurisdiction, you may be right there.
Correct.
That
Jurisdiction
accepted
is something
jurisdiction.
else.
but the
Liability is something
No,
else.
that's liability.
liability is something
For the
different.
liability.
Jurisdiction, you are right.
Correct. Suppose the liability part of it. If I'm trying to persuade, please read as many ways as possible into the review judgment and the earlier order passed in May 1989. It said, please read into the settlement and find out if at some point of time or conscience is stopped, then the liability question will be revisited.
Mr.
Now, this is one
Tondjal,
of the extraordinary cases in very, very peculiar circumstances.
Mr. Tondjal, the question put is slightly different. You're right. As far as jurisdiction is concerned, after the judgment, the jurisdiction of the Indian courts is accepted.
Right.
Probably the argument to the contrary may not be acceptable.
I can challenge it.
Now, as far as quantum of compensation or the liability, or first liability and quantum of compensation is
Yes,
concerned,
please.
it's always open to the parties to say, I want to enter into a settlement, get rid of the litigation. And therefore, I agree without going into the question, either on my liability or the quantum of compensation, I'll pay so much.
Right.
So that's their stand. That we as a package agreed to this. And there are two judgments now, both of the first and the second judgment, the review judgment, which says yes. And the judgment, while the court agreeing why they accepted the package, they've given their reasons. And in the second judgment, as far as criminal liability is concerned, they said no, criminal liability will continue. That aspect. So that's the argument. Now, what you are trying to do is you're going to say is, please modify that settlement package. Can that be done unilaterally?
No, unilaterally,
And
In
if
that
we want
case-
to do it, then we'll have to upset the whole settlement.
not that's my endeavor is to say no, that need not be done. Except what's being put to me is look at a possible
No, there, if that happens,
defense.
look, let's assume, let me put it very clear.
Your Lordship.
I think almost as far as liability is concerned, it will be very difficult for them to say that they are not going to
But as the quantum of compensation is concerned, they may have a lot of defenses. They may have a lot of issues in that. You can't say that you will have a free ride.
Liability, the court has observed. The court deciding said that because the occasion to determine the liability, the extent of liability, the extent of causa, nothing arose.
I'll try
Both
to find
sides
out
took
if
a-
there is a way
both-
out
both-
of looking
both-
at that.
No, both sides
I understand.
took a conscious decision. We can't foreclose. I mean, we can't draw presumptions from their thought process and say, why did they settle? So if they settle, they must have known they have to pay. Because they knew they must have to pay, so they must have paid according to this. Now we find they must pay more, so just make them pay more. This is what your argument is coming
No,
from.
no.
It's not a degree, it's a compromise.
Of course, although
And there was
all those fees
there was a memorandum of settlement filed on the record. We don't think it is on the record.
No, 23.3 is.
Order refers to the memorandum of settlement.
it virtually nothing other than what has been reproduced.
Let's assume there's compliance of 23.3.
I certainly I know since almost since yesterday morning onwards we are trying to get back to the same question in different forms.
Yes, you are right.
I try to answer
Yes.
one way or the other, and that's because of I thought a very important concern which if you have very precise formulations of a principle in accordance with relevant legislation which can be easily stated with some modification, some amendments, then of course the task is different. But the task is entirely, vastly different here. Therefore, to find some answer to a curative petition by the Union of India says, yes, there are errors which I must own now. Why I must own now? Because we are party to two important procedures. And secondly, the question of the unfolding set of events under the determination sanctioned by the Honorable Court under the Bhopal Catholic Act and the scheme have now thrown much more broader light than what it was in 1991. So, as Union of India, acting under Section 3 and 4 of the Act, can I close to those unfolding set of events and still say, well, court has said you do this or that, and therefore I say I must now no longer call upon the Supreme Court, having acted 142, to continue to call upon UCC to add an additional dimension of liability. The question therefore the Union of India asks the answer will be no. The court probably should be persuaded to ask UCC to get into that question because the error which we are trying, therefore the curative petition, and therefore the question of adding on to the liability will be seen from what the statutory authorities are determined on the application of principles set out in the scheme. Unless the UCC at any point or said no, when the constitutionality of the act was in question, and this court sanctioned the act and said you go under the scheme, which means anything which could have been determined under the act and the scheme by the process of the statute, the welfare commissioner, was to be something brought up before the court at a later point of time, if, as I said, 3 and 4 persuaded me to bring it before the court. This is what we are trying to do now. So to say that you look at from any other angle, namely what an additional compensation by insurance, or you take it up because it's a parent's welfare state, with great respect, I say they would stop somewhere only when the other questions are.
Anyway, we are just making it clear that the utmost liberality you'll have to wind up today.
I'm sorry.
At the utmost liberality you'll have to wind up today. There's still 50 minutes, but that's the maximum we can give for this. No one appeared. We have to hear. We said we will not hear the others, but we'll give them a little time to say whatever they have.
We are grateful, my lords. We
We have instructed, but still we don't want to shut out anybody, so we'll Give you a little time and we have to hear Mr. Salvo. So you will have to at least wind up today.
Great.
Because tomorrow we'll wind up the case. Well, no, we will go.
Section 4. Just maybe a little digression.
Yes.
In the Charanlal Sahu judgment, I just make a note of it. Your Lordships will note that is paragraph 92. The judgment is in volume 2 of the respondent's compilation. Just make a note of it. I'll read it. And one is para 92, other para 117. We are talking about the parents patria responsibility of the Union of India, the content of section 3 and 4. In para 117 of the judgment, while affirming this act, the court said that these are the concerns which you will keep in mind. Section 4, due regard, proper representation, and not slipping into any lapses on the part of effective representation and all that. to ensure that no harm results and so on. Enterprise is held to an obligation to provide as it is so on and so forth. Then paragraph 92. It is urged before us that there is an absolute and strict liability for the enterprise just carrying on the agent of the operation with cases in this country. Further submitted that there is evidence and records that sufficient care and attention had not been given to safeguard against the dangers of leakage and protection in case of leakage. Indeed, the criminal prosecution that are launched against the chairman and others as indicated before charged them along with the defendant in the suit with the delinquency in these matters and criminal negligence in conducting the toxic operation. So, as in the instant adjudication, this court is not concerned with the determination of the actual extent of liability. We proceed on the basis of the law and engage with the court in MC method. Is a decision upon the basis of what damages will be payable to the victim in this case. When the practical question arises, what is the extent actually payable and how will be so and so. Connection referred to the order passed with this court on May 4, 1989, giving the reason why the settlement arrived at figure indicated. So the whole thing is set out here again. This constitution bench also looks at paragraph that May 4, 1918 an order. And so that's how ultimately when they say in para 93, 92 end that the deprivation or curtailment, the rights of within the page 348, the last part of para 92. That's one of the reasons why the act was sustained. And para 94, one more observation which talks about why the history of this case shall not go in vain. And please also turn over to paragraph 97 in the next page, talking about section 3 and 4. Line about 5. The expression exclusive is explicit and significant. Exclusivity cannot be whittled down or watered down, must be given its full meaning and extent, corroborated with the use of expression claim for all purposes. Duality of rights is given to the central government along with victims also. The enforcement of the claims arising in the Bhopal Catholic slaughter. It amounts to be so cumbersome, it will not be speedy, effective, and equitable, not be more best or more advantageous for securing the claims of the leakage. Therefore, I would urge the court that section 3 and 4 call upon Union of India to repeat again that a duty must be discharged because I was trying to place with the Lordship that while both the judgments have looked at the history of the settlement and why it is germane and relevant, just want to keep these 2 pages flat to show that the genesis was from the District Court of Bhopal and how we travel all along. Therefore, the proposal dimension being present right from the institutional proceeding, and Union of India was certainly not averse to it, having regard to the immediacy of the succor to be provided to the victims. So this is at page 390. The whole order and the caption at page 391 called proposal from the court to the parties for reconciliation, substantial interim relief that has system. That's how it reads. Just make a note of paragraph 6 at page 393. Paragraph 6 and we do want to say this is that since right from the inception of the proceeding, the judicial role played has been exemplary in one sense that immediate succor, immediate justice. So it originated and then, fortunately, UCC, whatever
Always-
the parties in this.
It is always so in all these.
So they have
national
court-
suits, you need succor then and there. What's the point? Otherwise, the legal heirs will benefit.
Why I go back to it is that the rationale.
Frankly, I'm not able to find any doubt on the manner in which the settlements took place or the initiative of the government or the stepping into the shoes of those people who would not be able to prosecute, the role of the court, sometimes pushing them to make sure that a reasonable settlement at that time came through. All this has played a role because it was one factor known was that the assets within the country were a much smaller fraction of the total amount which has ultimately been paid. If you take up everything which they had, you still would have got a fraction of it. Now, as and when you got a decree, as and when, that's why the discussion on that. As and when you got the decree, as and when you got the finality to the decree, as and when that finality would go to the US courts for enforcement because the claim there would not be satisfied,
Right.
are all factors which weighed with everybody. We can't say now that we got the money, remove those factors.
No. That's not. I think how I.
No, you are putting
frame the phone.
you are
my
putting
submission.
your arguments as I've understood in the latter part of almost 7 hours between yesterday and today is that there were some facts which were not known as how they would unfold. And those facts having unfolded in a particular manner,
Right.
that's good enough ground to fasten them with liability for additional liability, but don't reopen the settlement because that's the settlement under which we are beneficiaries.
Right.
This is, as I understand the broad, and don't go on technicalities, whether it's security, whether it's something else. But since it arose out of incident of this nature, ignore all those niceties and fasten some additional amounts on them as per the current. This is some in substance of what you're saying.
I
Anything else?
तो इनके पास 10 स्टोरी की बिल्डिंग है, फाउंडेशन को वही बनाना चाहते हैं, 5 फ्लोर ऊपर और चढ़ानी है, वो करना है।
Yours is just pick up
वो FAR नहीं मिला है।
sufficient.
Anything else which you specifically want to say in this one?
And
We've understood.
why
something.
what is that?
Anthony, there is no doubt in our mind, at least what you are canvassing. Whatever way we go, they don't go there. But certainly there's no doubt in our mind as to what you are seeking to canvass. To that extent, you have succeeded. You have put forth your point of view. It's constructors. We understand the point of view. Maybe I've tried to abridge it, having heard you over a period of time, as to what the line of direction is. Because the moment you get into technicalities, you are in difficulty.
We sit back in the chair and see how do you provide an answer to this question. It's like looking at the rough edges of a diamond and making it a good diamond. Therefore, this is a case one where some rough edges are there. And therefore, if I have to handle a diamond, I have no problem. But the rough edges of the diamond are there. And that's why we're trying to say this is...
And it should be done in a manner the diamond doesn't disappear. Yes, that's all.
Let me just quickly go through my note and
Yeah.
I'll try to conclude. And
Which
in
is the
my
note- which is
note,
the
I've
note you
also
are-
given references to
Which is the
Yeah.
note you are referring to now?
submissions. There's a separate note given. Also,
Submission.
Submissions by the attorney.
That's right. Just quickly run through it.
Yes.
Some maybe little people will feel bad with me for that. I began. This is some very interesting quotes which I thought I can place it to just put it in perspective. Whitehead was an American philosopher contemporary of Bertrand Russell. And this quote comes from his book called Process and Reality. And Bergson, of course, a French philosopher. And
I tell you one factual aspect. After review judgment, there are fresh claims filed.
claims have been filed even today. As far as claims,
So there are substantial number of claims were filed even after review
there
judgment.
are two sets of claims. One, those who fall within this 5.74. That is the final number. But within that, there are claims which keep coming up regarding the so-called.
So there were fresh claims filed even after review. Review was decided.
Yes,
Very large.
after review.
The Suzuka asked more than once. Is this 675 paid or is it to be paid? There is an affidavit filed by the union. Their case is not that there is any amount remaining to be paid for which they need money. Their case is compare the assumptions of 1989 with the actuals and revise the settlement. They gave figures of what they have paid. My lord saw two figures yesterday, 1548 and 1509. What is 1548? They have explained 1548, Madam, in an affidavit. And in that affidavit, your lordship will see the figures, including this pumped up figure of the revised figure from 20,000 to 521,000, were all paid. And it came to 1548 when they came to your lordship. Now, if your lordship sees in the curative page 329 P7, so at least let the factual position be here of nothing is to be paid.
The second volume of curative.
The NGOs are saying the government should pay us more, to which the government is saying we owe you nothing more. I'll show that. Please see.
That I've given that. Sorry.
Just one.
The note.
See P7.
Salve, you pointed out in your own
Yes,
survey.
very good. Within the note which I have given, there is a reference to it. I'll come with a certain footnote so that this clarification is made.
No, no, in this, Mr. Salve said you are saying that you don't have to pay any
Total amount that
So the NGOs are claiming amount.
whatever received amount has been paid.
Is it your say that you are liable to pay more to the
That's right.
to the NGOs?
Would your lordship just see the one page so that
Not,
you're
we are
clear?
not liable. The UCC is that person.
No, you are liable.
Page number?
320.
Whether you recover from UCC
Volume
different matter.
security petition.
Therefore, I put it directly to you. As a government, as a welfare state, as something else, are you liable? You say, I want to recover from Carbide. That I understand. No difficulty.
That's a table.
Then we will note that the government wants to pay more. But the government doesn't want to pay more.
PC page 329, P7.
That
329, P7.
chart.
Yes. And I will marry these figures, compare them with the security petition, which, and the attorneys note, unclaimed one, claim 2, 3 months. It's different. And restoration and data.
There is a problem.
Look at P7. Number of cases, death 5295, same as present.
Yes.
Yes.
See page 320.
Since you want me to conclude today, let me.
Yes, Mr. Salve, I want him to.
Yeah, otherwise,
Correct.
I will run through tomorrow.
Yes. No. We don't want you to do that. Certainly.
That's a threat, Mr. Salve has said now.
No, I only asked you a question.
I'll
You, according to you, more amount is to be paid because see, there will be an issue which will crop up by reason of the requirement for you to take out insurance policy in the manner provided after the curative petition has been done. So the manner of paying additional amounts or may be required to be paid for these NGOs, are you saying you are willing to accept the liability if you find in your favor?
We are not answering to any. I'm talking about
It's very easy to dip into somebody else's pocket and take out the money. Question is, are you willing to dip into your own pocket and give it the money?
I would probably
Then see whether you can dip into their pocket or not.
I'll answer that.
Yes.
Very.
Yes, please.
A capital para A.
Yes.
Your lordship will lead the courts you own and read through them.
Yeah.
But Bergson I thought very interesting. But it says in order to think change and to see it, the whole field of physical pressure, right? Some of them artificial, created by philosophical speculation, the others natural to common sense. Now let me see. The curative petition has been filed by the Union of India as a parents' patria as victims of the world's largest industrial disaster, seeking enhancement of compensation in the settlement. Submitted the fundamental lack of completeness of fact touching upon the quantum of liability of Union Carbide Corporation. Consequently, the quantum of damages payable have initiated the settlement, affirmed with the Honorable Court in the order dated so and so, and judgment dated so and so. Both in the first settlement judgment and the review judgment, the Honorable Court underscored the possibility for a second look at a settlement and the need that may arise to do so. The fallibility of endorsing the settlement without leaving room for reconsideration has informed the Honorable Court in holding so. Position taken in the Honorable Court has been always a room for a second look is also in tune with instances in other jurisdictions. The courts have been very slow in giving their final stamp of approval to settlement or compromise in such class of cases. That's the US Supreme Court judgment. The Honorable Court will approving the settlement that observed that the same was not final, was based on certain assumptions of truth, and as I said, assumptions are unrelated to reality. The elements of justice of the settlement will seriously be impacted. Following observations on the Supreme Court judgment, the settlement judgment is significant. These are broad and general assumptions underlying the concept of justice of the determination of the quantum. The total number of cases of death that are permanent, total or partial disability, or what we call catastrophic injuries, is shown to be so large. The basic assumptions underlying the settlement becomes wholly unrelated to the reality. the element of justice, the determination that a truth of its factual foundation would seriously be impaired. The justness of the settlement is based on the question of truth. Indeed, different opinion, the interpretation of law and questions of policy, or even what we consider wise or unwise, but one speaks of justice and truth. These words.
But on these categories, attorney, nothing on these categories, the amounts have been lesser. People have been lesser. The expanded category, therefore, we began that yesterday, was that the expanded category is there where, on account of the incident occurring in that area, you thought it appropriate to give some kind of a solace amount to everybody because somewhere or the other it had, would psychologically or otherwise affect people apart from serious medical issues which have been caused. That's not, if you take out that category, there is no problem in all these cases which you're talking about.
Then the other category.
Partial disability, serious disabilities.
They are. That's where we had to step in 2010 and give them.
Chart, your chart
of-
itself shows, the first chart you gave itself shows the position.
In my notes,
No, that Tony is the right position. In spite, after even including the enhanced compensation, the figures would be within the limit.
Yeah.
Figures would be within the limits. The difficulty has risen because of the expansion in the category of minor injuries. That's the reason. I've done my.
It would have been less. I mean, it doesn't require too much of mathematics to it.
No.
The fact is, if you take down the first note, first note you gave, the last column, additional requirement required to be paid. Some are less, some are more.
Correct.
If you take out this 955
No, that's
crores, then 675 less, you are well within the reach. There are extra money available. It's only on expansion, or therefore we kept on saying it's an expansion of the claims of minor injuries that all this has occurred.
I have not read the entire note because there are subsequent.
I'm saying the portion you are citing will not apply. Because the portion you are citing applies to in the unforeseen eventuality of a very large number of serious cases being detected. That's not what has happened.
No, if you also look at the subsequent pages of this note, which explain
Okay.
the reasons why the claim 1, claim 2, and claim 3 in the curative petition are sought to be explained in the subsequent pages of the note. Yes. Page.
Even in yesterday's note and today's note, there is a discrepancy. Yesterday's note, you say that actual number of cases of temporary disability were 35,455. And the note which you are reading on page 7, clause B at the bottom, is 3434. Today's note, page 7, paragraph 13B. Actual figure of temporary disability is 34,343. And yesterday's note contains the same figure as 35,455. 1,000 more. We don't know what is the correct figure.
In the note which had
Today's note, you
that's
say,
right. That's page. This what I have done is for page 5 of this note. These are updated up to 2022. That's why I sought your lordship permission to
so
be updated.
as far as this temporary disability is concerned, how many are there? Total number of cases 35,455 or 34,343? Because with each case 50,000.
Yes, it is 34,340.
So yesterday's figure was not correct.
That's right. At page 5.
Not correct.
Between 2010 and 2022, this difference is the reason. That's why I put the updated figure. There's in some cases, the number has gone down, in some cases gone up. So that's why these updated figures, I think, are important for the purpose of taking a bird's eye view of current situation. Then paragraph 7 of my submission, the earlier paragraphs all deal with what has been stated in the review judgment and the settlement judgment. If all the essential facts relating to the number of deaths and the nature of medical afflictions that been present before the honorable court. It can be said with certainty that the quantum of settlement would not have been what it was, even though it could be said to be hypothetical. But due to fundamental errors in the determination of even the ad hoc settlement upon principles of expeditious resolution, or the agonizing claims of the Bhopal victims stated the tortfeasor retained an unquantified sum of money to be to the detriment and loss of the gas afflicted population. The retention of such quantum of money, which would have otherwise been shared with the victim, can be said to be akin to unjust enrichment, submitted that in all such circumstances where the quantification of damages, compensation through a process of settlement or otherwise exposed to legitimate challenge, the principle of unjust enrichment, the need to dislodge his benefit, and the person or entity was retained as a result of errors or otherwise, can be located in amalgam of merger of one, the right to remedy, access to justice and fairness of outcomes, all of which are now constitutionally guaranteed. The judgment of the Honorable Court in Indian Council for Enviro Legal Action endorses the affirmative duty of the court to undo such retention of benefit. In dealing with all instances of unjust enrichment and understanding a wide comprehension of the principle of unjust enrichment, the Honorable Court will persuade to also, after paying attention to the aspect of the finality of the judgment in paragraphs 103 to 140 thereof. Then para 8 looks at Permanent Court of International Justice judgment and on the question of reparation. What do you mean by reparation? Just a few sentences there. The essential principle contained in the actual notion of an illegal act, a principle which seems to be established by international practice, in particular arbitral tribunal, that reparation must, as far as possible, wipe out all the consequences of the illegal act and re-establish a situation which would, in all probability, have existed if that act had not been committed. And that's the principle. Now, paragraph 9, I said the observations review judgment can be legitimately construed and let us keeping open the need for subsequent process reviews. Regardless of the conclusion for the settlement judgment in answering question J, and the imposition of certain obligations to the Union of India to fill certain gaps in the quantum of compensation submitted as what's being canvassed is the Honorable Court on updated facts and circumstances is a continuation of the review process. The curative petition therefore deserves to be treated as a necessary, essential, and indispensable recourse to justice. To underline, I say it's a continuation of the review process and not a initiation of a fresh, independent process. Therefore, that's why I said the Huda judgment may have to be endorsed in an additional way. And this would probably be the better way of going about it. Then paragraph 11, in held a rubric of immediate evidence that where there is no precedent, establishment of precedent will lead to multiplicity of action. It is held if men will multiply injuries, actions must be multiplied too. For every man that they do ought to have its recompense. Then page 10, there are two other dimensions I thought you will also look at it. Page 9, bottom, paragraph 21. The MIC gas leak, even with an act of negligence and breach of the obligation, the duty of care, and the duty not to act negligently. Having breached the duty of care and be responsible for the MIC gas leak as an act of negligence, the CIL was under further obligation to do all things and take measures to rectify the consequences and impact of his act of negligence. The settlement entered into between UCC as the parent company, so and so, the reason of majority shareholding and other factors related to the commissioning of the plan, operation control, and Union of India cannot be construed as effective and final the quantum of compensation. The bargain of settlement for an inadequate quantum is seen as an attempt to bring to a close prematurely all liabilities relating to compensation. If only a fair and final closure in the issue of quantum of compensation can be said to be relieving the from the subject of liability. As long as such a fair and final closure has not occurred, it can be stated that UCC continues to be in wrong, in not effectively, and finally rectifying the consequences and the impact of its negligence. Therefore, UCC was not only in breach of his duty of care obligation, but also in breach of his obligation to rectify the impact of his act of negligence. This twin breach of obligation is a continuing wrong. That there is a need for a further extension of the principle of egregious irreversible. The concept of continuing wrong or continuing injury is a matter of procedure falling in the domain of limitation of action. These are statutory prescriptions. Even in the matter of application of continuing wrong or continuing injury, courts have felt the necessity of having a flexible approach. As long as it shows that the wrong continues to have a non-abating effect on impact on life and physical well-being, the court will lean in favor of an expansive application of the continuing wrong principle to do complete justice. This is a case of both a continuing injury and therefore a continuing wrong, as also a case of continuing right. It is well settled that where wrongful act is of such character, the injury caused by it continues, then the act constitutes a continuing wrong, well stated in 1959 Supreme Court. Is then para C, the settlement can be reviewed by the Honorable Court. Paragraph 24. The settlement judgment is also the review judgment that aligns in the uncertainty of fact relating to the number of deaths, nature of injuries, and the increasing number of people affected both by patent and latent impact due to exposure to methyl isocyanate. The uncertainties expressed in these judgments reflect the state of uncertainty that prevailed in similar mass tort situations. The asbestos-related litigation was England, the United States of America. But over a long period of time is a classic example of the limitations that claimants, courts, governments, and scientific experts are faced in such situations. In view of this, no part of the judicial process can have a dimension of estoppel that it would shut out our examination of due and just claims. The fundamental right of acts of justice must prevail over all of the technical and procedural dimensions of administration of justice. So, para 26, there is a reference to this because in the counter affidavit and their written summary, they talk about two judgments, 2007 and 2011. I would like to look at it like this. The unfolding sets of events placed and occurred in the curative petition. The two applications dealt with in Bhopal gas periods also in 2007-9 SEC. The intervention applications filed by parties in the curative petition added petitions also. And the proceeding time taken by the Welfare Commissioner. Together demonstrate beyond any doubt that the facts and figures reckoned for the purpose of the settlement are not sacrosanct and are no longer final and govern such matters. Then paragraphs 28 to 30, I looked at some of those practice of settlement procedures in the US courts. May just look at that. I don't want to read it in sense. Then, and heading D, I try to look at how UCC will bear continuing liability. That's notwithstanding all the internal corporate agreements they have made. Look, one submission in the context of paragraph 35, 13. Bandhu Mukti Lordship said, look at 32. What is the scope of adjudication powers in 32? It's worth looking at what the Lord said in Bandhu Mukti Morcha and the scope of Article 32. Now, why I'm talking about it is not a 32 proceeding, but since the court has withdrawn everything at 142, being a final court, everything is in the hands of this court. So, paragraph E, so I thought I'd bring to the international position on liabilities. So, given the scope of the global expansion of trade and commerce and the possible impact on human rights violations, certain international principles towards imposing obligations and liabilities on corporate and trading entities have been involved. The UN guiding principles on business and human rights set out the following principles relevant on reliance can be paid. I quote, these guiding principles are grounded in recognition. One, states' existing obligation to respect, to protect, and fulfill human rights and fundamental freedom. The role of business enterprises and specialized organs of society performing specialized functions required to comply with all applicable laws in respect to human rights. The need for rights and obligations to be matched to appropriate and effective remedies and fees. These guiding principles apply to all states and to all business enterprises, both transnational and others, regardless of their size, sector, location, ownership, and structure. The guiding principles should be understood as a coherent whole and should be read individually and collectively in terms of their objective of enhancing standards and practices with regard to business and human rights to achieve tangible results for affected individuals and communities thereby contributing to socially sustainable globalization. So similarly, the OECD guidelines for multinational enterprises also provides principles toward responsible business conduct in a global context. Then paragraph 1, they respect human rights, avoid infringing on the human rights of others, and address adverse human rights impact involved within the context of their own activities, avoid causing, contributing to adverse human rights impact and adverse such impacts. Then seek ways to prevent and mitigate adverse human rights impacts that are directly linked to their business operation, products or services by business relationship, or even they do not contribute to those impacts. So I just place them on record only to say that at the international level, we have these issues, international commerce and trade and impact and human rights, has received attention. The one I remember when, in the context of a termination for health treatment, the local hospital in England, Cambridge State Authority, Reliance was placed in Article 10 of the European Convention. And, the submission was that, of course, it would not apply directly. That's before the 1998 Human Rights Act. I remember it was a judgment by Ross J. who said these are persuasive principles of public policy, and so internationally recognized. For the persuasive principles of public policy, which your Lordship has noticed in Vishaka and a large number of judgments later. So, business enterprise obligation, states' right, obligation to protect human rights violations and to see that there is an effective remedy and their redress. Your Lordship also make a note in volume one of my compilation. There are two. Okay. Please give it. I made other set of compilations on.
No, which is this another?
I'm not going to read that. I want to.
No, of course that. But what is the compilation?
The compilation, certain articles and extracts from books, but I Lordship will just pick up volume 1 of this compilation on the meaning and definitions of fraud and mistake. That's just make a note of it in volume 1, serial numbers 4 and 5. Serial numbers 4 and 5, volume 1. I don't propose to read it.
Thank you. Our general, the last 2 days for 7.25 hours. And list tomorrow.
So we give
10 minutes each to both this, both of them.
more than 10 minutes.
Sorry, we are not willing to hear you. Either you can compress it in 10 minutes or you can't. Whichever way you want.
Not also one request.
Yes.
Papers are still not on record.
Which one?
My lords, we will attempt to satisfy, my lords, that a para of the relevant order was not read out. That was
Do
not,
that. Do that.
tomorrow we'll do that, my lords.
But I was only saying, your lordship will hear them, no problem. Not papers.
See the last order.
Yeah, exactly. The one I'm worried at what the attorney has filed. Now, it shouldn't be, the attorney's file, not because
And what we have
What
filed.
we have said, we are not, since they are here for 2 days, we give them each 10 minutes to say what they want to say broadly. Attorney has to address, he has addressed.
Not so.
Thank you.
Get to
ये कर भेज दीजिए पब्लिक हाँ नहीं इतनी भेजिए बस बाकी ये नहीं